Oh, sorry. These people are with the planning department in Orange County. I'm a great host. Stober is the director of planning and inspections for Orange County. We've worked with them quite a bit on a number of things. This is a great staff, and they're happy to help in any way they can. But a lot of things come up around land use, PUD, bona fide farm, what you can do, what you can build, not build on a farm. Agritourism is obviously a big issue in the county. Pat Mallet is the deputy director here. He's been around for a while, like me, and has a history in private business, like I did. But they were going to talk to you about some of the issues they've run into regarding farmland and farmland use and planning. Pat Mallet.
Folks hear me in the back. A little hard of hearing, so anyway, yeah. To add to what Mike said, farming is something that we deal with in planning and zoning a lot. I adjust the volume. Hear it now. That better? Okay. So as Mike said, I've come from a development land planning background. I've done it in private sector, public sector. I've been doing it for about 30 some odd years. All aspects, farm and farm issues are a big part of my work experience and my work planning department. So I can speak all day about farms and how they relate to or don't relate to zoning. Probably a day-long lecture, but I won't. This is just a high altitude overview of where that stands with planning and zoning. Department overview, we've got about slightly less now. We've eliminated a few positions, but plus or minus 32 employees. We've got 3 different divisions. Building inspections, that's where you could go and get your building permits, whether it's for an accessory structure or a house or a non-residential building. Development services, that's my group. We cover current planning, that's planning, zoning, subdivisions, and then erosion control and stormwater engineering. Long range planning covers special projects, comprehensive planning, and GIS map. And oh, by the way, so just for the folks that don't know, we are physically located between the library and the parking deck. It's next to Weaver Street. We're on this, planning is on the 2nd floor, building inspections, environmental health. Haven't seen this. Development services, for the most part, I'm generalizing here, but development services is the group that deals the most with farms. Some of the products and services that we provide, we produce zoning reports. That's a information tool that gives you information about a specific
hold the microphone up.
About a specific property. Is it just like going out, or am I?
No, it's going out.
I just try to talk louder. How's that? So we produce zoning reports and GIS maps. Those are useful if you're looking at a specific type of property. Process building permits and land disturbance permits, zoning compliance permits, non-residential site plans, subdivisions made all types. We process rezoning cases, special use permits, and we deal with farm issues. This is a sampling of the major maps that we use with our daily work. One to the immediate left is our zoning map. All properties have a zoning category. They're in our planning jurisdiction, the county's planning jurisdiction. Middle map shows a watershed map that sort of delineates our watersheds. It's the benchmark that we point to. We're a delegated community by the state Environmental Management Commission. And
Great. There you go.
Okay, is that better? Okay, all right, we're rolling now. Okay, watershed map. We are a delegated program of the State Environmental Management Commission, and we have watershed protection measures throughout the county. They're tiered generally according to critical areas, protected areas, and then some limited unprotected areas. That map pertains to densities. It pertains to impervious limits, and the like. And we also have a future land use map. That's embedded with comprehensive plan that's the guide towards what things should be developed towards in the future. These are our working documents. We have the Unified Development Ordinance. That's our zoning and subdivision regulations. And then the comprehensive plan. This is a 2030 plan, which we have in place. We're obviously working. Many of you have probably heard we are working on our updated 2050 plan. That is probably set, correct me if I'm wrong, side to go back into community outreach and input in the fall. We think we've gone through a period of information gathering for the commissioners, so it will be updated. Okay, zoning and farming. State granted authority to jurisdictions, counties a long time ago, 1959, and it said that there's basically you can regulate things, you can create subdivision ordinances. That's not loud enough. The fun. This okay. Just keep changing. Okay, so the state said you can regulate things, you can create zoning ordinances, you can create subdivision ordinances, but you can't regulate bona fide farms. They specify what bona fide farms were. Those have special exceptions, exemptions. You, in large part, from a zoning perspective, can't really regulate them. The current definition that is here in 160D, 903A, bona fide farms, includes the production and activities related or incidental to production of crops, grains, vegetables, ornamental, flowering plants, dairy, livestock, poultry, and other forms of agriculture. It also includes agritourism. This is a hot topic. I generally find that people either love or hate farms, depending on this definition, and the thought that agritourism is so broad you can decide anything. That's a bit of a myth. There are limitations to what you can do for agritourism. But if you read through that definition, it's what I call intentionally wide open. It's what I call the Rose version of experiencing a farm out in a rural setting. And there's also the definitions for buildings and structures. But the takeaway is there's two components. There's the farm activity and bona fide farms, and then there's agritourism. And this just goes through land disturbing activity. There's two different components of the legislation. One relates to zoning, the other one relates to land disturbing activity. The only thing I'll say here is that for obvious reasons, there are certain types of land disturbing activity that are not regulated. Regulated land disturbance activity on a farm, that would include the construction of a dwelling or a house. That is regulated land disturbance, and it counts towards a threshold that could cause you to have to get a control or grading and control order. Previous presentation had a pretty good graphic covering the 4 different ways that you can qualify as a bona fide farm by the state statute. I structured this one to sort of overlap because there is some overlap between the two. You can have all 4 of these on a piece of property. I also want to talk about the myth. It's a pretty common myth that PUD status is the only way you can qualify as a bona fide farm. That's not true. You can be under a managed forestry plan. You can have a North Carolina Department of Revenue ag stamp, temporary or permanent, and from a zoning perspective. And then you can have your IRS status. Fairly common to see properties that have quite a few of these, but it only takes one. These are some examples of resources and tools that we have on our website. Size brought a stack of, we have a farm fact sheet. I think it's pretty useful. It's a 2-pager. It covers the basics and points you to resources. And then we have 2 affidavits, one for zoning and one for land disturbing activity. That is something that we created. It's not a requirement. Another myth is that planning and zoning christens or determines you are a bona fide farm. The farmer decides they are a bona fide farm and raises their hand and says, I'm under, by the state statute, I'm a bona fide farm and I'm conducting farming activities and or agricultural products and agritourism. So what we created was 2 affidavits covering the 2 state statutes. On a voluntary basis, the farmer submits that material, it cites where the farm is, it ticks off how they believe that they qualify, and then provides supporting evidence, whether it's evidence that they're in a PV status, their ag stamp, or whatever. Planning department, we take that information and we put it into the permitting system. So when someone calls in, whether it's an inquiry or a complaint, have that on file, say to the requester, this information is on file. Highly likely they're continuing to claim their farm status. But at the end of the day, farmer raises their hand and says, I'm a farm. It's up to you, Orange County, to prove it wrong. That's incredibly difficult. This graphic talks about regulated versus non-regulated activities. The point with this slide is you can have a piece of property that has regulated elements to it and non-regulated elements to it. Do a lot of work with farmers to sort of pinpoint what are you doing on the property. Do you include some activities or elements that are regulated, and do you require certain types of permits, and what is under farm use. In this graphic, it's showing all of the areas that are farm usage in yellow, and then the regulated activities, i.e. the house, the driveway, those are regulated from a land disturbance perspective, may require an erosion control, stormwater permit. It requires a building permit. We work with building inspections downstairs to document that. Residential dwellings, they also require well and septic. Take it over to the side. Hopefully this thing.
All right, so I'm going to just briefly go over more or less that agritourism elements of state law. So I'm going to ask for your help. So can you all, I'm looking for 3 different ideas of what agritourism might be from you all. Does anyone have one idea of what an agritourism activity might be?
Strawberry picking.
Okay, great. Strawberry picking, that's 1. Anyone else? Wedding venue, that's 2. Anyone else?
Pumpkin patch.
Pumpkin patch, that's 3. Okay, great. I would say wedding venue, maybe. It depends on the relationship to the farm. If it has a relationship to the farm, if it even is on the farm, because we did that too. No, I have a farm, and I also own this property over here in Hillsborough. That's a wedding venue. That's related to my farm because I sell my farm products at the wedding venue. The other 2, strawberry picking, pumpkin patch, I think those are classic definitions of agritourism or conceptions of agritourism. As Pat has already covered, the state of North Carolina, since 1959, has broadly told us planners, when it comes to farms, back off. You've got no jurisdiction here. We do have subdivision jurisdiction. We do have stormwater jurisdiction. But otherwise, and we enforce the state water quality rules. So we have stream buffers, we have floodplain protections, and so forth. But we don't have zoning authority. We can ensure that what's the exact legal phrase, I can't remember, the efficient and rational use of land through subdivision. We can still regulate that. We can ensure that if you're going to put 5 houses on a 10-acre farm, that they're placed there in a logical manner that will eventually, should it fall out of farm status, ensure that they meet our subdivision regulations. But we can only provide guidance on that matter, because we do allow for multiple dwellings to be placed on one property if it's a farm and it's serving the farm purpose. Because we don't have zoning authority. We cannot say you have one primary use per property based upon the underlying zoning. And further, so that's just farms. Further, 160D 903 is where we look to tell us when we don't have authority. So this is not in our local laws, this is not in the UDO, this is not in our land use plan, this is in state law. And basically what we are charged to do when somebody raises their hand, as Pat said, we have to defer to their claim of farm status. We have to interpret the state law. We don't have local laws that give us authority to say you can and can't do this. We have to go all the way up to the state law and say, do we have authority in this matter? In our opinion. And the farmer often will say, No, you don't, every time. But when do we have to thread the needle and say we think we do? So what I'm going to do, oh, thanks, Matt, is zoom in on a couple of these phrases, and I need you to help me figure out when does that line in the sand stop? So if we go to the next slide. So we're looking at this first clause, the underline, and Pat already brought these up, but bona fide farm purposes include the production and activities relating or incidental to the production of crops, et cetera, and livestock. Incidental. So when does incidental activities end? It certainly doesn't end at a parking lot. Does it end with lighting that violates our zoning ordinance because you're going to have a haunted pumpkin ride at night, and you need to have lights, but they don't comply with our ordinance, and they're disruptive to the safety of people on the road? Does it include, can we have signage, blinking neon signs that we otherwise prohibit? What is an incidental activity? There are incidental activities where certainly the county's code of ordinances and our legal authority to protect public safety enter into the equation. And I'll note, Pat already brought this up, the environmental health codes and all the health codes still apply to farms. So if you're doing food preparation, septic and well regulation, all of those still apply. So yeah, you can have axe throwing on a farm, but you can't allow minors to do it. All of those still come into play. You can't, and there's case law about things like shooting ranges. Are shooting ranges inherently part of a farm because it's a rural setting? We'll come back to that in a moment because that is actually the defining case law. So we go through all of this. Activities incident to the farm, so they do provide a definition, include, but not exclusively, existing or new residences constructed to the residential building code. So if you're going to build a house on a farm, you still have to meet building code. Situated on the farm, occupied by the owner, lessee, or operator of the farm. And we also have to defer to the claim that those people inhabiting those homes are either the owner, operator, or lessee, or a tenant. And other buildings or structures sheltering or supporting the farm use and operation. So this is the law that says you have no zoning authority. So when someone comes in and they say, well, yeah, I mean, my house is part of the farm. Okay. That barn is part of the farm. Okay. And that trailer with that guy that always bugs the neighbors is part of the farm. And we're not allowed legally to say, well, how? We have to defer to that claim. We have to defer to a claim that, oh yeah, well, I mean, theoretically, we have the haunted pumpkin ride. We also have this carousel out here. We also have, we run into this haunted houses that don't comply with building code, that are just an old repurposed barn. And yeah, we don't meet the parking requirements, and we have to be allowed to do this. So this is our first challenge. Is when are the activities not incident to the farm? When do they take on, per our local ordinance, a significant separate primary use or principal use? When does it become a retreat center? When does it become a recreational activity? When does it become a residential use rather than a farm use? And that's an interpretation. And it's subject to legal appeal, it's subject to challenge. So if we go then to our second challenging area, it's down here. And we'll zoom into that. Okay, yeah, we highlight it and then we zoom in. So we get to we haven't even touched agritourism. So agritourism, I know I'm running out of time, but I want to present you with the challenge of how we are to determine what agritourism is. So if we go to the next slide, let's zoom in on it. So we just look at the language. So again, we have to interpret the state law. We don't have local laws on agritourism because we are told thou shalt not regulate agritourism. But agritourism, and there have been a couple of high-profile cases lately about what is and is not agritourism. But the state law says that agritourism means any activity carried out on a farm or ranch that allows members of the general public for recreational, entertainment, or educational purposes to view or enjoy rural activities. So in Orange County, what is not a rural activity?
Concerts.
Is it? If you're at Red Rocks out in, where's that, New Mexico, Utah, are you enjoying the rural landscape of Red Rocks when you're at Red Rocks? I grew up in Cincinnati. When you go down to Riverbend Amphitheater, are you enjoying the river, which is in full view when you're down there. If it's on a farm, it's not. It's an amphitheater. But that's when does it stop being enjoying rural activities and you are there for a separate, distinct activity that has nothing to do with the rural setting. You could place it in the middle of Chapel Hill, you could place it in the middle of downtown Durham or Greensboro, and it would still function the same. You would still have the same needs, and you'd still be attracting the same and appealing to the same public audience, regardless of that setting. But if it all is threaded with that rural setting, you would now have a challenging interpretation in terms of land use. When does it stop being part of the rural activities? That key is rural. And then we get to the even more challenging. That's actually not the most challenging part of the state law. This second part is agritourism includes any building or structure used for public or private events, including but not limited to, they give you weddings, receptions, etc. And other events that are taking place on the farm because of its farm or rural setting. So this is the state law. It's a bad law. If you eliminated this part, and if you eliminated this part, my job gets so much easier. But as long as those are in there, this is very hard. So we have to vet every one of these. Most of them are pretty easy. I would say if you go, we have forestry management plan on a fairly large property, and the folks who own that forest really, really want to have for-profit mountain biking activities out there. So, but their argument is that, well, this is an awesome, excellent forest, and we're preserving it as such to be a forest for the enjoyment of the rural setting for this forest. And yes, we're going to charge everyone an admittance fee and charge them for parking to use this mountain biking trail. So when does that become a recreational use, which we do regulate? And we require a special use permit for it. We require parking, we require lighting, we require access. They'd have to have a DOT driveway permit. And they would also have to have a disturbance permit that oversees. And when do we say, no, this is a rural activity to enjoy the rural setting, to enjoy this forest that's been protected? I don't have a good answer for you, but this is the reality we live with on a day-to-day basis. And as it relates to the tax exempt status that Dana's going to talk to you about in a moment, when do we call her and say, we don't think this is not what they're saying they're doing? And when do we challenge them? Because as Pat said, in North Carolina, and largely in the United States, we take the position of you're innocent, so you're proven guilty. So your claim of farm status is your claim that we defer to until we challenge you. And we have to have evidence in order to deny that claim. So we appreciate it when people ask before doing, because it helps everyone kind of navigate and figure out how can you have a bona fide farm activity that meets these very broad allowances. It's not hard. But if we're going to get a call and we're going to have something on file, ideally an affidavit that we can't require, but we do ask for, we can say they do have a farm plan. They do have a small entertainment venue here, but they also have a forest, or they have a pumpkin patch or whatever, and they manage it, and they have the IRS receipts, and they're in the PUD program, and that meets this very broad language of the statute. That's a bad law, but it's the law that we have in North Carolina. So if you want to change it, I can't help you, except to tell you that you should talk to your elected representatives in Raleigh. The sheriff has worked on this because we've had large events at some of our farms, and he's trying to do something about that. So he's an advocate on your behalf. I can't advocate for you. Your commissioners can, or you can call the phone for your representatives, but this is the law that we have today. And we have some more resources. I'm finished, but we've restructured our website, as most of the county has to meet ADA requirements. Taken a lot of good information. Some of it down, some of it's been relocated. So call us if you're looking for something. We do have hard copies of this Bona Fide Farm Guide, and Pat has some links here, I think on the next slide. And if you have any questions at all, please give us a call. We have cards. We have the info sheet, and I appreciate your time. I don't think we have time for questions, but we'll be hanging around.
Go right in.
Yeah.
So thank you.